The Supreme Court just dropped a 9-0 ruling, and almost nobody saw it happen. All 9 justices agreed, and what they backed could shape your retirement money for years to come. If you planned your future around a pension, a 401k, Social Security, or a state tax break, the fine print matters right now, because this did not happen in loud headlines or viral clips. It happened in a courtroom, and by the time most people hear about it, the damage is already done. That's what makes this so serious. The biggest changes in America often arrive quietly, wrapped in legal words that regular people never have time to read. Then one day, people find out the rules they trusted are not as solid as they thought, and the cost lands right in their monthly budget. This ruling matters because it pushes back on that pattern, and it does it at the highest level possible. At the center of this fight was a simple idea. Can the government invite people to build a long-term plan around one set of retirement rules, then turn around and change those rules after years have passed? Not for future workers who can still adjust, but for people already deep in the system, people who already made huge life choices based on those promises. The court's answer was clear, and it was unanimous. The government cannot do that so easily anymore. Before I reveal what the court actually said, quick question: subscribed yet? You're going to want notifications on for this, because once you understand what changed here, you'll see why this ruling matters far beyond one lawsuit and far beyond one retiree. It speaks to anyone who ever trusted a state benefit, a retirement formula, or a tax rule when making choices about work, savings, and where to live. And the people who understand it early are the ones most likely to protect themselves later. Think about what retirement planning really is. It's not a weekend decision, and it's not something most people can rebuild from scratch when they're already halfway to the finish line. It's years of paycheck deductions, years of skipped spending, years of saying no today because you believed the system would still work tomorrow. That kind of planning changes where you work, how long you stay, when you move, and what risks you can afford to take. The person at the center of this case looked at that reality and refused to accept a late rule change as normal. That person had built a future around official rules already in place, not rumors, not handshakes, but written policies. Then the government shifted those rules after the planning had already happened, after the commitment had already been made, after the chance to easily change course was gone. That is what turned one personal fight into a national legal turning point. The court focused on a basic principle with a legal name, but the idea behind it is easy to understand. It's called reliance, and it means you made real decisions because you trusted rules the government put in front of you. You stayed in a lower-paying public job because the pension made the deal worth it, or you saved a certain way because the tax treatment gave your plan a shape. You acted because the system told you those rules mattered, and the system benefited from you believing that. That point is bigger than it sounds. A retirement system is designed to guide behavior over decades, not months. It tells people to save, to stay, to contribute, to wait, and to structure their entire future around a predictable payoff later on. So when the government creates that structure, enjoys the stability it brings, and then later yanks on the foundation, the damage is not abstract. It's deeply personal. For years, states had wide room to adjust retirement-related rules. They could change pension formulas, add new taxes to retirement income, tweak benefit timing, or reduce features people thought were part of the deal. And when challenged, the usual defense was simple. Governments need flexibility, budgets change, conditions change, and policy has to change with them. On the surface, that sounds reasonable, but it leaves out the people who already built their lives around the earlier promise. Picture a teacher who stayed in the classroom for decades because the pension at the end helped make the lower salary bearable. Picture a firefighter who passed on private sector money because long-term security was part of the bargain. Picture a state worker who counted on a certain benefit formula and planned housing, healthcare, and retirement age around that number. When those rules shift late in the game, the harm is not theoretical. It lands in a real kitchen, on a real budget, in a real household. Now add another group that people often miss. Retirees who moved across state lines because one state treated pension income or retirement withdrawals more gently than another. That kind of move is not casual. People sell homes, leave family, switch doctors, change routines, and start over because the tax math made it make sense. If a state later reverses the policy that pulled them there, that is not a tiny policy edit. It can blow a hole in the plan they moved for. And here's one of the biggest changes in the ruling. The court did not just say people's expectations matter. It changed who has to do the heavy lifting in court. Before, retirees often had to prove the government acted unfairly, which is hard, expensive, slow, and often out of reach for regular people. Now the pressure starts on the state. The government has to justify the change when real reliance and real harm are on the table. That matters more than most people realize. In court, the side carrying the burden often starts the fight in the weaker position. If the state now has to explain why it should be allowed to damage plans built under old rules, that is a major shift in power. It means retirement planning is being treated less like a wish and more like an interest the Constitution can actually protect. Don't just watch this channel and move on. If someone in your family has a pension, is close to retirement, or moved for tax reasons, send this video to them today. Most people won't hear about rulings like this until a letter shows up, a benefit shrinks, or a new tax hits their bank account. By then, the shock is real, and the time to prepare is already slipping away. Now, this ruling does not freeze every retirement law forever. States can still make changes, and lawmakers are not suddenly powerless. What changed is the standard they must meet when those changes hit people who already relied on the earlier rules in a serious way. That difference is huge because protection is not the same as perfection, but it is far better than being left exposed. So who stands to gain the most from this decision right now? The first big group is public employees, and that covers a lot of people in every part of the country. Teachers, police officers, firefighters, public nurses, city workers, county staff, and many others accepted jobs that often paid less up front because the back-end security mattered. That security was not a side note. For many families, it was the reason the career choice made financial sense at all. Over time, many states ran into pension stress. And when those systems got expensive, lawmakers in some places started changing formulas, raising ages, trimming cost of living increases, or reducing expected payouts. In some cases, those changes touched workers who had already spent years, even decades, serving under the older terms. That is where this ruling bites hard, because it says those late-stage changes deserve serious constitutional scrutiny. In plain English, the court is saying this: if a worker joined under one clear set of retirement terms, stayed for years because of those terms, and shaped a life around them, the state cannot casually rewrite the bargain. That does not mean every challenge will win, but it does mean the worker starts from a much stronger place than before. And for millions of public workers, that alone could change how future legal fights play out. The second major group is retirees and near retirees who made location choices based on state tax policy. This is a huge deal because retirement income is not treated the same way everywhere. Some states are much friendlier than others when it comes to pensions, Social Security, or money pulled from retirement accounts. Those differences can mean thousands of dollars a year. And for people on fixed incomes, that difference can decide whether retirement feels stable or scary. When people move for that reason, they are not chasing a trend. They are protecting the life they spent decades trying to build. They are asking where their savings will stretch farthest, where their pension will keep more of its value, and where their monthly bills will hurt less. If a state later changes the policy that influenced that move, the effect can ripple through housing, healthcare, and basic peace of mind. The third group may be the most overlooked of all. It's not just today's retirees. It's people in their 40s and 50s who are still saving and still shaping their retirement map. A lot of them assume Supreme Court fights matter only once you've already stopped working, but that is too narrow. This ruling reaches ongoing planning too, because reliance is not one single moment. It builds with every year you act under a stable set of rules. If you have spent 15 years contributing to a retirement account because your state's tax treatment made that strategy attractive, that matters. If you chose a savings rate, a withdrawal timeline, or an investment path because certain rules were in place, that matters too. The court's reasoning recognizes that retirement planning happens over and over, contribution by contribution, year by year, not in one dramatic decision. That means people still in the building phase may have more protection than they think. Here's something worth doing right now. Hit, like if you want more breakdowns that turn complicated court language into plain English, you can actually use. A lot of channels chase noise, but stories like this shape real lives, and they deserve attention before the headlines finally catch up. If you care about what happens to your future money, stay with me, because this next part is where the ruling becomes practical. The court laid out a basic test that future fights will likely revolve around. The first question is simple. Did people actually make financial decisions based on the earlier law? Did they join a pension plan under a certain formula, move states for a tax advantage, or keep saving under a specific retirement framework because that framework was in place? If the answer is yes, the first door is open. The second question is about harm. Not every tiny administrative update becomes a constitutional showdown. The change has to seriously damage the plan people built under the old system, not just annoy them or create a mild inconvenience. We're talking about real losses, real setbacks, and real changes to the money people counted on for later life. Then comes the third question, and this is where the state feels the heat. If reliance happened and real harm is likely, the government has to come forward with a strong reason for why the change should still stand. And not just a vague complaint about budgets or a broad promise of modernization, but something strong enough to outweigh the damage done to people who planned in good faith. That is a much taller hill than governments were facing before. So what should regular people take from all this? First, do not treat your current retirement rules like they will always explain themselves later. If certain policies matter to your plan today, start keeping records that show what those policies are right now and how you relied on them. That means official state tax pages, pension summaries, enrollment papers, benefit explanations, and anything else that shows the rules you acted under. Why does that matter so much? Because a legal protection is strongest when you can point to facts, dates, documents, and decisions that tie your life choices to the rule in place at the time. A saved webpage today could become powerful evidence tomorrow if a state changes course and says your earlier planning should not count for much. Waiting until after the rule changes is often when people realize they failed to preserve the proof. The next move is not panic. It's a calm conversation with a financial advisor who actually pays attention to changes in law and policy, not just market performance. Ask how your state's current tax treatment fits your long-term plan, and ask whether your strategy depends heavily on rules that could become future targets. You do not need fear to act wisely. You need awareness, records, and a plan that does not ignore the legal landscape. If you are a public employee, go one step further. Pull your pension documents and compare what you entered under with any changes your system has gone through in recent years. Look at retirement age changes, cost of living changes, benefit formula changes, and any shifts that reduced what people once expected. That does not mean rush into a lawsuit. It means know your own facts before someone else tells you your expectations were never that solid. At the heart of this whole story is trust. Retirement planning has always depended on trust more than most people admit. People trust that if they save, work, contribute, and plan carefully, the framework they were given will still be there when they finally need it. Without that trust, the entire system starts to wobble, because long-term planning becomes a gamble instead of a disciplined life choice. For a long time, that trust felt shaky when governments changed direction. States could point to financial pressure, lawmakers could talk about flexibility, and ordinary people were left trying to absorb the hit. Many retirees and workers simply did not have the money, time, or legal muscle to fight back in a serious way. That imbalance is exactly why this ruling feels so important. It tells governments they do not get to treat reliance like it never mattered. If you've made it this far, take one more second and subscribe if you haven't already. Not because it helps me chase numbers, but because information like this is only useful if it reaches you before the next policy fight begins. These quiet legal shifts can affect years of savings, and most people do not find out until the consequences are already hitting their accounts. Stay close to this stuff now, and you give yourself a far better chance of staying ahead of it later. What happens next will be worth watching. Some states may try to protect current retirees while changing rules only for future workers, using so-called grandfathering to avoid direct conflict. Others may push right up to the edge of what this ruling allows and dare the courts to draw the line more clearly in the next round of cases. That means this decision is not the end of the story, it is the start of a new phase. Experts will argue about how wide this ruling reaches. Financial planners will revisit assumptions they once treated as stable. Lawmakers will think harder before they quietly reshape retirement systems for people who already committed years of their lives to those systems. And people who used to feel powerless in these disputes may now see a real legal path where there was once mostly frustration. It's also important to be honest about what this ruling does not do. It does not guarantee that every retiree wins every future fight. It does not mean courts will block every change, and it does not mean governments stop trying to solve real funding problems. What it does mean is that states now face a stronger constitutional challenge when their fixes land hardest on people who already relied on older rules. That is why smart preparation matters so much right now. If your future depends on a pension, if your location depends on tax policy, or if your saving strategy depends on current retirement treatment, do not drift past this moment. Know what rules you're relying on, keep proof of them, and understand that your planning is no longer just a private hope buried in paperwork. The highest court in the country just signaled that your reliance can carry real weight. And think about the everyday stakes here. This is not just about legal theories, academic debates, or one person's lawsuit buried in a court archive. It's about whether a retired couple can keep up with healthcare bills, whether a former public worker can stay in their home, and whether years of planning still mean something. It's about whether the government can move the goalposts after people already played the game by the posted rules. That is why this decision feels larger than one policy dispute. It speaks to a basic American expectation that if people act responsibly over time, the system should not punish them for trusting it. Save your money, do your job, make careful choices, follow the rules, and you should not be blindsided years later by a rewrite you never saw coming. This ruling does not solve everything, but it tells the country that expectation is not foolish. It deserves respect. So when you hear people say court decisions do not touch ordinary life, remember this case. A quiet 9-0 ruling can affect where people live when they retire, how much they keep, and how safe their future feels. It can change the balance between citizens and the government in ways that never trend online until the consequences get painfully real. And that is exactly why stories like this matter before the rest of the country starts paying attention. In the end, the message from the court is simple. When Americans build their retirement around rules the government created, that reliance cannot be brushed aside like it means nothing. The state may still act, but now it must answer for the damage when it changes the deal after years of dependence. For anyone saving, planning, or already living on retirement income, that is not just legal news, that is personal protection.